I'm attorney LAnthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first segment in a multi-part lawcast discussing Regulation A+. On March 25th, the SEC released final rules amending Regulation A. The new rules are commonly referred to as Regulation A+. The existing Tier 1 Regulation A, which does not preempt state law, has been increased to $20 million in any 12-month period, of which no more than $6 million can be resale by selling shareholders. The new Tier 2 offering, which does preempt state law, allows a raise of up to $50 million in any 12-month period, of which no more than $15 million can be resale by selling shareholders. Issuers may elect to proceed under either Tier 1 or Tier 2 for offerings of up to $20 million. Tier 2 offerings require additional disclosures and ongoing reporting requirements. Tier 2 offerings will preempt state blue sky laws for securities offered or sold to qualified purchasers, while Tier 1 offerings will be subject to full state registration and qualification requirements. Both Tier 1 and Tier 2 offerings have minimum basic requirements, including issuer eligibility provisions and disclosure requirements. In addition to the affiliate resale restrictions, resales of securities by selling security holders are limited to no more than 30% of a total particular offering for all Regulation A+ offerings. Both Tier 1 and Tier 2 offerings have minimum basic requirements, including issuer eligibility provisions and disclosure requirements. In addition to affiliate resale restrictions, resales of securities by selling security holders are limited to no more than 30% of a total particular offering for all Regulation A+ offerings. Both tiers will allow companies to submit draft offering statements for non-public SEC staff review before a public filing. Both Tier 1 and Tier 2 permit continued use of solicitation materials after the filing of the offering statement, and both allow the use of the EDGAR system for all filings. Regulation A+ offerings, both Tier 1 and Tier 2, will be available to companies organized and operating in the United States and Canada. The following issuers are not eligible for a Regulation A+ offering: companies currently subject to the reporting requirements of the Exchange Act, certain investment companies under the Investment Company Act of 1940, blank check companies, which are companies that have no specific business plan or purpose, or whose business plan and purpose is to engage in a merger or acquisition with an unidentified target. However, shell companies, which are companies with no or nominal operations but are not otherwise blank check, are eligible to use Regulation A+. Issuers seeking to offer and sell asset-backed securities or fractional undivided interests in oil and gas or other mineral rights are ineligible. Issuers that have been subject to any order of the SEC under Exchange Act Section 12J entered within the last 5 years are ineligible. Section 12J allows the SEC to revoke the registration of a security if the issuer fails to comply with federal securities laws. Issuers that become subject to Tier 2 reporting requirements and do not file required ongoing reports during the preceding 2 years are ineligible. And issuers that are disqualified under the bad actor rules are ineligible. The new rules are expected to be effective on or near June 19, 2015. As always, details determine diligence, so the ongoing support of an experienced OTC law firm is highly recommended. I'm securities attorney LAnthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.